Good afternoon.
Good afternoon.
Sorry, did you ask me? My name, Michael Takac.
You say good afternoon.
Sorry. It's still Michael Takac.
Well, thank you for joining us in Oviedo this afternoon. Welcome. As you know, my name is Amanda Carl. I am the Vice Chair of the Takac JNC. You've been in front of us before, so you know kind of what we do here. We'll go around, introduce ourselves, tell you where we're from. We'll give you 2 minutes to make any opening remarks, and then we'll fire away with questions, and then give you a minute at the end to make any closing remarks. One change today, we do have a guest, Belucia Exposed is here videoing. Give him your good side, sit up straight. And,
Better put that camera right behind me.
And David, we'll go ahead and start with you.
I'm David DeArmas of Kramer Price of DeArmas in Orlando.
Good afternoon, Your Honor. Glenn Citro from the law offices of Horowitz and Citro in Orlando.
Good afternoon, Andy Bardos with the Gray Robinson Law Firm.
Good afternoon, Brett Renton with Schatz & Bowen in Orlando.
Good afternoon, Your Honor. Atra Brownlee with the Brownlee Law Firm.
Good afternoon, Craig Dyer, Public Defender's Office, Daytona Beach.
Go ahead.
That makes me Michael Takac. You've had the application in front of me. It hasn't been that long ago. I would tell you that if you're at all familiar with it, better or worse, not a lot of drastic change to it. Updated some things, hopefully correct some typos. My practice about me was, I was an attorney about 20 years and did a lot of litigation and a lot of appellate work all across the state, meaning literally from the Keys to Pensacola. So I appeared in every district court of appeal except for the third, in briefing and oral argument. I did a lot of trial work of all types and have now sat on the bench. This will finish my 12th year in January when the next term starts. So I think I have as broad a range of expertise as you can bring to an appellate bench if you're looking for that. I have a desire and burn to be able to meet my goal of write well, write concise, which is like, think like I have a book in my chambers. It's think like a writer, not like a lawyer. Sometimes we can be convoluting and going a long way around things, and I think if you ask what's the burning desire to go to the bench, is to be in that academic atmosphere surrounded with others that really focus on writing well so that everybody understands what the law is. That would be me in a nutshell.
I had the pleasure of vetting you, Judge, and everybody had such great things to say about you. You seem to have really found a way to be assertive and have a command of the courtroom without insulting anyone and always being courteous. So kudos for that. So with that said, can you tell me a little bit about your judicial philosophy and what you'd like to bring to the bench?
You know, I laugh, I say I'm a little bit like an appellate judge. Now, I like to decide what's right. I get a lot of, judge, what do you want, you know, or if the court will, it's like, no, you're the litigator, you bring it in front of me. I think I should rule on what's right, because I think when you start going astray from studying it, you know, that's the best way to bring surety and finality. So I just try to limit to what the issue is in front of me. The other thing that I like to do is, you know, listen to all sides and apply the law. I don't like to try to reinvent things. There was a judge I practiced in front of, I love him. He's retired now, and he was great. When I was with the Attorney General, I appeared in front of him a lot, and I wanted to voir dire a witness, and the other side objected. I didn't get to voir dire him, and I was kind of dumbfounded. We approached, and he goes, come up here, and I'll never forget, he put his hand on the microphone. He goes, yeah, I never liked much like that rule anyway, Mike, so, you know, you can do this later on the cross or something. I remember thinking, oh wait, the rule's the rule, so, I love him, and I probably take a lot of my attributes from him, and I won't use his name in case everything gets horrible, but I remember fondly, and that's the one subtle difference I have, is I think the rules are the rules, the law is the law, and what I told people when I was trying to become a judge, and what I follow is, my job is to apply the law. If that law stinks and you hate it, don't assume that I love it. It may very well stink. Your job is then to go to the legislature and get it changed. So that's kind of what I take to the court on. You know, the law is the law, the rules are the rules. I'll give you the facts and apply what we have to do here, and I'll do the best I can to give you, you know, if it's my job to determine the facts, find what they were, and if not, then just to make sure it's getting presented to the jury in an orderly fashion.
Thank you. Now this is going to be switching gears completely, and you might not know the answer to this because clearly you're not practicing eminent domain law anymore. But I'm wondering if you're familiar with recent decisions out of the Florida federal courts that are applying Florida's full compensation standard in eminent domain cases that are brought in federal courts rather than the just compensation standard, such that litigants or landowners now are being awarded attorney's fees and costs in federal actions. Are you familiar with that at all?
If a new case has come down to do that, it hasn't crossed my desk, no, so
Right,
I'm
it
not
would-
familiar with it, I'll take your word
Gotcha.
for it. As a landowner in Florida, I'm all for it.
Yeah.
Um,
As am I. They're not paying my bills, but,
Right.
yeah, okay, I just wanted to get your thoughts on that and see some analysis, but if
Well,
you're unfamiliar with it,
The only
then-
thing I can tell you is that I did, when I went to law school, I was in North Carolina, and so I had an occasion, I was doing some work, I can't remember if it was for Senator Morgan when I worked for him or the bosses I worked with, but there was a difference in how other states pay. In fact, when I was working in eminent domain, we represented one of the firms I was with, represented Discount Auto, which was a place all over the place, and they called us for the property they had in Georgia, and I had the pleasure of telling the senior partner, great, I'll go to Georgia and represent them, but we're getting $500 for doing it, because I thought,
Right.
wait, we may get them local counsel. One thing Florida has, it's a great advantage, makes it a great reason to live here among whatever others are, is that the constitutional interpretation of full compensation, because you can get things like your attorney's fees awarded to you, and so I think that's, I mean, that's a great thing. So I think it's wonderful that the federal courts are letting Florida property owners do that. I haven't litigated it from a condemning authority standpoint, I don't know, but it's, the rationale, having lived it for so long, doing so much eminent domain, I'm certainly in favor of it. I understand the rationality of it. The key is if people are worried about abuses, then that's probably the court's job to make sure that fees aren't accepted. Because as I understand in Florida, we're still awarding reasonable fees, although they have changed the statute now, where it's a percentage of benefit. I don't know what the federal courts do.
Yeah, it's complicated because it's not the federal standard. So.
Yeah, and I don't know that they have the same mechanism that we do in the Florida statute for measuring what the benefit is.
Yeah.
Good luck to them.
Yeah. Thank you for that. I'll let
Judge,
Jenny
I have
finish
a
her
question on your, on the application itself. Number 47 talks about your Martindale Hubble rating, and it's got a BV, but you have a look, et cetera. And I was curious about it, so I pulled it up, and it actually says that at the discretion of the individual, meaning you,
Right.
It has been sealed or won't be made public, I think is the term
Really?
used. And so I was curious whether or not, you were aware of that. Did you actively ask them to remove it, or was there some comment?
No, I'll tell you my whole history with Martindale Hubble.
Okay.
I went to a firm, and there was some, when I first got out of law school, there were some lawyers in it, and I think they were rated CD. I'll be blunt with you, I said, I think I'm better than a CD lawyer, but I never got around to applying because I was doing other things. I went because I wanted to become a good litigator, that's why I went to law school. I joined the Attorney General's office. And lo and behold, I get a letter one day. I was right, I was better than CD. Martindale Hubble sent me a thing that I was BV. And I said, well, that's interesting how they find that out. And, you hear that they do methods. And I realized that because I was with the Attorney General, all the places where I was really practicing, nobody knew me. So I took it as a compliment that even back where I used to practice, my reputation was BV, but really the people that could appreciate what I was doing, they weren't the ones consulted. So I found out by contacting Martin. I said, how'd you do this? And he said, well, send us 20 names and we'll contact them and see how you are how you're rated. And then also I found out you get a $100 raise if you're the Attorney General, if you apply and do that. And at that point I said, if I can pick my references and it's only like I'm doing it for a raise like everybody does anyway, so I'm done with Martindale Hubble. I found out enough about it. And so I never worried about it anymore because it looked like it wasn't as a distinction as I thought it would get out of law school. I'm pretty confident I could find 20 people to say I was an AD lawyer. All I had to do was look at my last 20 trials. And so I just really stopped pursuing it. Now, if it became sealed in all candor, it could have been years ago, like, are you worried about it? Do you care? And I would have said no. Otherwise, it may have been caught up when I became a judge. When you first become, and they talk to you about security, I made everything confidential. But there was no beef with Martindale Hubble. I never pursued another ranking with them when I found out that I was in charge of my references. I didn't care.
Yeah, like I said.
I just didn't feel like it applied to me.
It just said you hadn't really looked at it, and so
No.
I was curious. I pulled it up. It had no rating for you, and it had you know, sealed at the person's
Yeah, I
prerogative. So I was curious.
I was a
appreciate
BD in
it.
the, I want to say it was 90s.
Sure, and
I
I
haven't-
appreciate that explanation.
I haven't bothered with it, not to downgrade Mr. Hull or
Sure.
Mark Hill or their fine publication.
So a couple other questions I've got for you. Do you believe that we should only send up individuals to the governor's office who have judicial experience in their background?
No, I can't tell you that I believe that.
Why?
You know, I think you have to find the best candidate you can. Somebody could walk out of law school and just be a brilliant constitutional scholar, and that's what they excel in. You know, you could be out of law school and have been a judicial clerk, a Supreme Court clerk, or something like that, where you're exposed to it. And I think when you're looking for a judge, there's a lot of factors that go into it. It's not just, you know, what have you done? Have you done it right? Have you done it well? Helps. I do think a broad experience helps, but I recognize you're also looking for, you know, a commitment, a dedication to the work, to the academic work that it takes, to the just hard work, burning the eyelashes it takes. I would never say that you have to be a judge. Nobody's born a judge. You never get a judge. If you had to be a judge to become a judge, so even that common sense out.
What's the longest you've taken as a judge to issue a ruling on a motion or a trial?
I'm pretty quick. I'm pretty quick. Probably the longest I've taken, I've probably gone up and had in my office 30 days of monkeying and editing, probably with a termination of parental rights order, because if you feel that strongly, you get to that. But there's a couple reasons. I think the attorneys that work those cases, they do a lot of work, and I found that a lot of times a big complicated case, maybe it's taken several months to get all the evidence in, because then people are leaving, they can't be there. Unfortunately, not designed to be that way. I found the best way to get them focused is have them write their closing arguments, and sometimes, you know, I'll get a lot of spaghetti with it. Those people are doing wonderful work, probably can be some of the proudest lawyers in the courthouse and probably the worst paid. And they're doing a lot. And so maybe they don't have the time to shut down and write that as some of us might do in our private practice, the luxury I have. So there's a lot to unwind, and so it takes a little while to unwind it and then write it the way you're satisfied it. And I apologize to all my assistants, or secretaries, whatever title you want. I said, look, whatever you write, you can always write it better. So it's not a reflection on you when I'm going to red pen it. I just don't like what I do. So I've spent a lot of time on that. I think I'm within the guideline of that. I don't know anything that go real out of hand.
And what do you think is the largest challenge to the court system's ability to maintain its independence or integrity?
You know, the court, our government, every institution we have, every job, it's filled by people. So the biggest challenge is people, quality of the people. And that's just not the individual in the job, but it's the other people taking their role serious to put them in that job. Let me speak as a lawyer, since that's what I did for a while. If you read the ethical code, not only do you have the obligation to behave correctly, you have the obligation to report those who don't. I think they've watered that down a little bit, but still, so when you're a judge and somebody's flying around, you need to kind of reel them in a little bit. But other lawyers could do it. You know, I think when people start sweeping things under the rug, then things can run amok. And so if you just spread that to every branch, the legislative branch, judicial, lawyers, everybody in the profession. You know, we're a government of the people, by the people, we're as good as the people. And so sometimes it's nice to be reminded that, you know, we've been blessed with a lot. Nobody has to tell me that. My family, I always got inundated with the stories from my parents who immigrated. Hey, you know, we're grateful to be here. It's good to remind people of that. I try to do that when we have jury selection. I know it's an inconvenience for everybody, but keep in mind, you know, this is what separates us from other countries. That answers your question.
Thank you very much.
Judge, I have a question about statutory and constitutional interpretation. So when you're interpreting a statutory or constitutional provision, what is your process or method? What do you look to? And does it differ depending on whether it's a statutory provision or a constitutional provision?
I don't know, well, I think the benefit of the constitutional provisions, especially if you look at the US Constitution, they've been around a lot longer, so there's a little bit more comfort in case law. But I think you look at the words, and you read the words first, and what do they say? And it's the same for a statute. It's pretty simple, you know, what's the common sense, what do the words say? And then you start looking back at you know, the cases that have interpreted, if you're so fortunate. And that's where I start, you know, and that's about where you end the cases. I will say that I don't think anybody would accuse me of saying, well, that's what it says, but this is, you know, what I want to say or it makes sense. Like I said, it's a conflict. I'm having that struggle right now with the risk protection orders. In fact, that's more or less one of those questions came up when I was in Tallahassee last time. Maybe overcomplicated, so I don't want to do it now, but the order's written and you read the words, but it calls for an awful lot of hearings and it gives them a lot of suggestions, but it doesn't change the evidence code. And I'm curious and watch it because in my circuit, the forms were a little bit convoluted. I found law enforcement couldn't use them correctly, which is why I put in my packet, you know, a suggestion. I met with them all and said, look, here's the way I'm reading the statute of the guy applied, and you use these if you like. And some forms on it, and in my circuit that I know of, or certainly in my county, I don't think anybody's been able to successfully use it yet. And that's one of those deals where, well, this is what the law says. I don't know any judges applied it wrong yet, but you know, that's what you have to do, and so the legislature will have to fix it. It's a problem. Now I understand other counties do not having that problem, so maybe just law enforcement when they get more comfortable with using it.
Thank you.
What do you think about PCAs?
They're not very helpful to the people that want to know why they did not prevail. May not be as helpful to people that do prevail. I understand that. But I'm also practical where I've practiced long enough and I've read enough pleadings that come across my bench to know that probably some people deserve a PCA without much further comment. I'm not trying to say 50-50 amount, so I wouldn't say abolish them. But, I mean, I think that's the obvious thing that everybody thinks about. What you don't want to do is use them where, you know, people start to question the bench, you know, where you're trying to duck one or, you know, not doing the workload. I'm not saying that anybody thinks that, but that's the concern. If a lawyer's PCA, he's not happy about it. You know, that's, you know, sometimes people are taking an appeal of something that's maybe well decided. Maybe a PCA with a citation is a little bit better than just a lengthy PCA. I can tell you that I have written opinions, many of which have been affirmed by PCA, and I've enough said, you know, my word spoke well enough, but I'm not trying to flip about it. I don't have an opinion that they're a huge problem. I understand the frustration for people that will maybe be looking for something else, and you just have to be careful when you use it.
We have time for one more question. Anybody else has a question? Okay, if you'd like to make some closing remarks,
I would, you know, I would certainly like to, you know, for the opportunity to apply for the job, and I think I still have a while where I could be a good contributor to the District Court of Appeal bench. I hope you agree with me and give me that opportunity, so I appreciate a nomination to the governor. That's the main, you know, that's the main reason for coming to be here. The secondary is if the governor get word that I have a nephew I'd like for him to meet, so he could consider recommending him to one of the academies in his next line of work. That wouldn't bother me either. But the application for the District Court of Appeal, I do think I can significantly contribute. I think I have a measure of writing. I know I don't know everything, and that might be one of my best assets. I think when I met last time that came out, I was very lucky, you know, to have a mother, a professor in college, who, you know, taught me, you know, you don't know everything. And Ben Franklin's statement when they were drafting the Constitution, that I try to keep in mind that I don't know everything. I have to be amenable to the ideas of younger people. Just for cell phone discovery of what comes off the internet, you know. So, yeah, I think there's a balance of that humility. I've been told, and I work on trying to make sure I have that. My best quality is that I do believe, you never know that you don't know everything. And so I hope to be given that opportunity by all of you, and I thank you for your time today, including the time of my interview, whether that was luck of the alphabet or not. I was able to finish duty, get down here, and so that's great. So thank you all very much.
Thank you. Happy New Year.
Happy New Year.
Yeah, Happy New Year to everybody. Happy holidays.
Have a good trip.